Hearing in the appeal, Chandler and the State.
Yes, Mr. Rowan.
My Lords, together with my learned friends Ms Buckley and Ms Jones, I appear for the appellant J. Chandler. The State of Trinidad and Tobago is represented by my learned friend Mr Poole. My Lords, leave was granted on the 2nd of August 2016 in respect initially of 3 grounds of appeal. 2 related to conviction, the 3rd concerned sentence. In light of the Board's judgment in the Pittman case, the sentence appeal was abandoned. Our case, therefore, focuses on 2 grounds. Firstly, a fresh evidence ground based on reports from Professor Eastman, which raise questions of diminished responsibility. And secondly, a misdirection or non-direction ground on propensity concerning what was known as the Haynes incident, a single incident in 2009, some 4 years after the index offence in October 2004. My Lords, can I indicate this? I don't intend, unless the Board wishes me to develop in oral argument the written submissions on the propensity ground between paragraphs 41 to 54. The point is a relatively simple one. I'm realistic enough, I think, to acknowledge that if it were the only ground, the prospects of the Board quashing the conviction on that ground alone are low. I don't abandon it, but the real point in advancing it or maintaining it is this. I suggest that in the event that the case were to be remitted to the Court of Appeal, in light of the submissions on the fresh evidence ground, and the Court of Appeal were then to order a retrial, if the point is a good one, then, by which I mean the non-direction on propensity, yes, the Board could so indicate in its judgment, and that would affect the course of any retrial. And in those circumstances, therefore, we indicated yesterday that the initial time estimate was perhaps over-generous and subject to any points the Board wished me to. I'm confident we won't take, I won't need as much time as initially indicated. Could I turn then to the fresh evidence argument? We need, of course, to succeed in applying to adduce the evidence at all in circumstances where this evidence is presented for the first time before the Board many years after the index offence, as well as the trial in 2011. We deal with the application to adduce at paragraph 16 to 28 of the case. That's electronic bundle 1736.
Sorry, can you give me the paragraphs again?
Yes, paragraph 16 of the case, EB 1736. There are 3 limbs to the application. We have to show that the evidence is credible and compelling. Secondly, we have to satisfy the Board that there is a reasonable explanation for not adducing it. And thirdly, we advance in any event that justice requires its admission. The principles which apply in an appeal such as this, when fresh medical evidence, in this case on diminished responsibility, is presented for the first time before the Board in circumstances where a defendant advanced a different defence at trial, in this case complete denial, are well established. And there are 2 cases on which we plainly place great reliance: the Nigel Brown case and the Daniel case, in which at least 3 members of the Board were involved. And my submission is, in effect, although there are obviously differences factually to some extent, in its core essential features, this case is really identical to the circumstances in those other 2 cases. And we therefore submit a similar outcome or identical outcome is required, namely that the Board can't quash the conviction plainly, because further investigation is needed. But in light of Professor Eastman's, we would submit compelling analysis, this is a matter which requires further consideration. And the matter, as in Daniel and as in Nigel Brown, should be remitted to the Court of Appeal in Trinidad for the court itself then to undertake a review of the safety of the conviction in light of the fresh evidence. Could I take you to the Nigel Brown case just to remind the court of the similarities? It's volume 1, tab 6 in the bundle of authorities, electronic bundle 1850. There was a character point as well being run on appeal, but it's only the fresh evidence point. You'll see from the head note, defendant charged with murder. He denied being at the scene, claimed the witness had been mistaken. A court-ordered psychiatric report on the defendant concluded that he was fit to stand trial, but although an accompanying psychology report raised an issue as to his mental state, defence counsel did not question his fitness to plead, nor, despite the lack of previous convictions, did he put the defendant's character in issue. So a denial defence run, although there was in that case a psychiatric report available, but defence counsel took the view not necessary to pursue it or not to investigate further. Can I take you to paragraph 60 on EB 1866, where the fresh evidence ground is dealt with? I'm not going to actually read it all, but in paragraph 60, the board records the fact of the reports available in 2004, coincidentally the very same year as the index offence in this case. And such evidence as was obtained at the time was that he did not suffer from any formal psychiatric illness, no evidence of psychosis or mood disorder. Evidence he used marijuana, and Dr. Garney considered he may be of dull, normal intelligence. Then a reference to some various psychological testing at 61. Because of the way the paragraph is expressed, no specific reference to the appellant. Inquiries made of Dr. Maharaj about his report, and then reference to a further report. And then at 63, on page 1867, one sees, and here the delay between the index offence and the fresh evidence was some 6 years. It's about 10 years in our case. But one sees on 29th July 2010, Dr. Latham prepared a report based on an examination of the appellant carried out in June 2010. And then it summarises the qualifications of Dr. Latham, who's in fact a colleague of Professor Eastman. Para 64, the report is summarised, the key aspects of it. Plainly, this was a case in which the issue was fitness to plead as opposed to diminish, but that's the only actual difference in principle. Over the page, electronic bundle 1869, paragraph 68, the board says the reports of Dr. Latham and Dr. Green were not obtained until fully 3 years after the conviction. A substantial issue arises as to whether the evidence should be received, reference to how the case had been advanced at court, and then this statement, there's no doubt the appellant's legal advisers should have been alert to the question of his fitness to plead, yet no medical evidence was adduced on his behalf, nor was this issue canvassed either on the trial or before the Court of Appeal, matter of obvious and grave concern. The board exercised by the fact the reports had been produced ex post facto without any explanation as to why medical evidence on the issue of fitness has not been produced below. Then a reference to the fact that attempts had been made to obtain an explanation from the representatives, which was a failure in the sense that no reply was received, which is the same in this case. And so at 70, the net position is the board is faced with a complete absence of explanation as to why the issue was not ventilated in the courts below. A reference to the fact the board is anxious to make clear, it shouldn't be assumed that even highly persuasive evidence produced for the first time at the final appeal stage will be admitted. Reference to Pittman, and the reference at the bottom to the fact that the general factors are not conclusive. An appellate court has the overriding statutory power to admit evidence if it's in the interests of justice. And then at 71, confirmation of the distinction of Dr. Latham and Dr. Green. And then this statement of principle, the ultimate, halfway down that paragraph, the ultimate penalty, a sentence of death, was imposed where a doubt remains about the correctness of the verdict which led to that penalty. Any court would be bound to ensure it should be, if it can be, removed, or if it cannot, that it should prevail against the carrying out of the sentence. The board has decided the fresh evidence must therefore be admitted, and accordingly the board remitted the case to the Court of Appeal, who should determine the safety of the conviction in light of the fresh evidence. As I say, the chronology is different, and the gap between the index offence and the date of the examination by Professor Eastman is longer. It's 10 years in our case between the index offence and the examination by Professor Eastman. It was 6 years in Daniel. But these features are common. A denial defence was advanced at trial in both cases, and no issue of mental abnormality was explored or raised by the defence team. Secondly, some years, many years after the conclusion of the domestic process, detailed examination by a highly regarded medical expert produces evidence which supports a defence of diminished responsibility, in this case, fitness to plead in Brown. Thirdly, there is an absence of explanation as to why the medical issues were not explored at the trial. I accept in Brown, in a sense, the mystery was even sharper because there was a report at the time which raised fitness to plead issues. Here, the inference we draw, although of course without Mr. Williams's input, the inference is there was no examination either by the state or by the defence of medical issues, although, as we now know from Professor Eastman, who has obtained such records as he has been able to, there should have been an issue of concern to the defence team if they had had possession of all relevant material, not least, as I will show you in a minute, a 2005 letter from the hospital to the prison medical officer raising questions on the part of the defendant, Mr. Chandler, of him having heard voices since he was 16 and psychotic symptoms potentially linked to drug.
I can't remember, did Brown give evidence?
No, we put his defence through cross-examination, I think.
I think he did. Let me just check.
No, I think my lord says he put his...
Unless I'm...
No, my lord, paragraph 12.
Paragraph 12.
I'm grateful. He did not. No, that's right. So thank you. He did not give evidence at his trial.
I mean, the fact that his mental condition was on the agenda is a slightly two-edged sword, isn't it?
Yes.
Because it slightly reinforces one's impression that the decision not to
was a tactical.
do it was a tactical. Well, if one's instructions are that one's client didn't do it, there are obvious forensic difficulties about saying that he did it under diminished responsibility, and that seems perhaps, in the absence of any information, a more plausible explanation than any other.
Yeah. Lord, I agree with respect.
Here, that's a consideration which is plainly of less weight if, as in Brown, there is a question mark over the ability of the accused to give instructions at the time of the trial.
Yes, my lord, that's also true. I accept that. And where the evidence, the fresh evidence, directly relates to that question, then to that extent, perhaps it balances things out.
In the present case, the appellant did give evidence at his first trial.
He did, yes, and it was a denial defence. And at the second trial, he did not.
But it was still a denial defence at the second.
Yes, it was. Yeah, through cross-examination. Could I just show you letter. It's in the supplementary bundle, a record of proceedings comprising documents not adduced below. I'm sorry there are so many separate volumes. It's electronic bundle page 1664, because Mr. Poole relies on this to some extent as showing that there was a report that contradicted Professor Eastman's analysis. It's 1664. It's a slim bundle called supplemental records, documents not adduced below. And that includes, obviously, not disclosed at trial, and on the face of it, therefore, not known to the defence at trial. But can we just look at this? So it's a letter, 5th December 05, so it's just over a year after the index offence. And of course, quite extraordinary, it's still 4 years from the trial. I mean, we have no understanding of why it did in fact take 5 years to get to trial for the first time. But what this is, well, it speaks for itself. He's referred for psychiatric evaluation after complaining he was hearing voices. His past psychiatric history consisted of one admission to Ward 1 at the age of 16. This appears to be drug-related, query, substance-induced psychosis. He claims he's hearing voices since the age of 16. The voices have been compelling him to stab prison officers. Voice tells him to attack officers and other inmates. He hears the voice when he's asleep coming from inside his head. Depressed of late, daily basis, and so on. Admitted truancy, using marijuana for 13 years. On interview, fair judgment and insight, though no remorse for the crimes. In my opinion, he has an antisocial personality disorder. He's not suffering with a psychotic illness. I've recommended a course of fluoxetine, which is Prozac, an antidepressant, to be reviewed in 1 month's time. So the submission I make about that is that any defence lawyer who got that letter would have been bound to seek, if they could get the funding, to have a full psychiatric report. Because the fact that this House officer had concluded that he was suffering from antisocial personality disorder and not psychotic illness was frankly simply the beginning of the exercise. You would be bound as a defence lawyer, competent defence lawyer, to pursue that. It's relevant also to this extent. Professor Eastman has dealt with the question of whether he considers that Mr. Chandler was faking symptoms when he saw him in 2014, and he gives his detailed reasons as to why he's satisfied that's not the case. But the point is, this is Mr. Chandler in 2005 being recorded as complaining of what are psychotic symptoms on one view. If he was someone who was trying to fabricate a fake defence, then it's very odd that in 2009, when he's on trial, that's not what he's doing.
What do we make of that? I mean,
well,
because as my lord says, there's a slightly sort of two-edged. I mean, I can see from one point, people say if this had gotten into the hands of trial lawyers, you say they would have sought a report. But I mean, what do we make of the fact that Mr. Chandler himself made nothing of this? I mean, well, because he's not, unlike Mr. Brad, he's not someone who thought to be incapable. He's an intelligent person, one can get. And
we don't know. I mean, one of the problems...
Well, why don't we know?
Well, we don't know because Mr. Williams has not answered any of the questions.
Well, what does Mr. Chandler say about it?
Well, you've seen the account that he's given to Professor Eastman in 2014. He's very vague about details. He's not...
I mean, there's no suggestion in that interview, as I can see, that this particular event was prompted by voices telling him to kill this particular person.
Well, in the end, the strength of the case is Professor Eastman's opinion. That's the basis on which this case is being presented to the board. The points that my lord has makes to me, I'm not dodging answering the question, but they are really questions that can only be examined by the Court of Appeal.
Well, I mean, the problem, I mean, I think the difficulty I have is being quite sure what the test is, because it said, well, it's obviously important to know why, an explanation of why it wasn't produced at trial, and we simply don't have that here. but it said that even in the absence of such an explanation, the interests of justice
Yes.
may require it. Well, what is it that pushes it over to the level of the interests of justice requiring, if a deliberate decision is apparently made, not to run this point at trial?
Well, even if there is evidence, I'm repeating the point. Of course, even if there is evidence that a deliberate decision was taken, if the evidence is such as to cause the board to be concerned that a miscarriage of justice may have occurred, then that's the test.
Yeah.
And there are numerous examples, both in the Privy Council and domestically, where the courts of appeal permit a defendant, exceptionally, to, if you like, run an alternative defence, even in a situation where they didn't do so first time around. In the end, it perhaps elaborating a precise test is difficult. It's a question of whether the board is uneasy in a capital case in the light of the fresh evidence that a person may not have had a fair trial. And the difficulty that the board is in, which is why I'm not inviting the board to quash the conviction, but merely to remit it.
But it would be impossible for us to quash the conviction.
Yes, it would.
I think you accept.
I accept that.
Because obviously there may be evidence called on behalf of the prosecution.
Yes, quite.
Yeah,
I mean, yes, precisely. At this stage, I'm entitled to say the evidence is uncontradicted. No doubt, of course, the state, if the matter would be admitted, would instruct their own expert, and there would then have to be a hearing about it.
Where does Professor Eastman deal with this letter? Remind me.
He deals with it. He doesn't specifically deal with it, but what he...
But he didn't have it at the time of his first report.
Oh, he does have it. Yes, he did.
Well, he didn't have it at the time of his first report, did he, or did he?
He does. His first report at EB 1545. Yes, he did have it at the time of the first report. It's EB 1545 at paragraph 174. You see that in his, he sets out at the beginning of his report all the documents that he had. But at 174 he says, returning specifically to the appellant, in my opinion, on the balance of probability, therefore, it's more likely than not he's experienced episodes of psychosis from his mid-teens. Although he was subject to assessment at St Anne's Hospital during the remand period, and this apparently revealed no evidence of psychosis, in my opinion, that assessment was inadequate and not such as to overturn the diagnostic conclusion I reach. So that must be a reference to that document. Those are the features which I say are similar, if not identical, to Brown. Could I also show you briefly the case of Daniel, which is tab 8, electronic bundle 1887. Lord Sumption and Lord Reed may dimly recall. Electronic bundle 1889. You see the defendant, appellant, had been convicted of the murder of his 16-year-old cousin, 25 years of age at the date of the offence, a man of good character. We see in that first paragraph, his case is his conviction is unsafe because fresh evidence from 3 expert witnesses, including Professor Eastman, demonstrate defence of diminished was open to him at the trial and should have been but was not employed, cast doubt on the voluntariness and therefore the admissibility of the statement he made to the police under caution. You see from paragraph 9 on page 1891 that the defence at trial, in circumstances where he was heavily intoxicated with drink and drugs at the time, was that because he was so intoxicated by drink, drugs and rock music, he didn't know what he was doing.
We can see in paragraph 7 that he gave evidence at the trial, accepted that he had killed the victim, and said, I mean, the statements quoted are all consistent so far as they go with diminished responsibility.
Yes, on the face of it, yes. One sees at paragraph 10 that, again, Dr. Ghani was involved, as in Brown. He concluded the appellant was fit for trial. He was not mentally ill, but has a personality disorder with psychopathic features, including inability to form relationships, etc., etc. So, at 14, one sees the board recording that there was material in the medical evidence from a Dr. Hutchison, who was also involved back at the trial stage, which could have formed the basis of diminished. And one sees halfway down what Mr. Knox for the state submitted. He said it's to be inferred that the decision not to run the defence of diminished must have been taken for tactical reasons. Miss Elder's an experienced leading counsel. She must have seen all the reports. She must have decided the reports would undermine the appellant's defence. He didn't have the requisite intent to be guilty of murder. And then they say, return to that issue. The evidence is then set out. Professor Eastman is a distinguished forensic psychiatrist. His findings are set out. At 20, paragraph 20 on 1895, we see that the state made really pretty much the same objections as Mr. Poole advances in this case. The decision not to run diminished must have been made for tactical reasons. Secondly, the new reports don't support a realistic defence of diminished. Thirdly, they are in any event unreliable because they depend on the appellant's own account of his previous history and the killing. They don't take account of the unchallenged, unchallengeable prosecution evidence, the jury's verdict, the evidence of those who know him. The board then deals with the tactical decision point. 23, reference to the Pearson principle. In any event, even if the board was satisfied that such a tactical decision was taken, it wouldn't refuse to receive the fresh evidence if it thought the evidence supported a defence. So one sees that the test is a permissive one in the sense...
At 22, it's been made clear that there simply wasn't the evidence available at the trial. I mean, the issue had been explored, had been investigated.
Yes.
And the reports didn't support the defence.
Yes.
And so it wasn't tactical. There wasn't the material there to run the defence.
Well, that's obviously right. I'm grateful. And the board reject, at the bottom of para 22 on page 1895, reject the basis, the suggestion that it was a deliberate tactical decision.
Yeah.
But even if it was, that would not be the end of the matter. I'm not dealing with the detail of this because obviously the facts are different, but the next section deals with, does the evidence disclose a potential defence? And the board finds it does at paragraph 40 on 1901. The board is of the view that this evidence, if accepted, would provide a credible basis for a defence of diminished responsibility. Professor Eastman, Dr. Green are both experienced and distinguished, and so on. And then over the page at 43 on 1902, most unusual case, the appellant was a man of previous good character who for no apparent reason killed his cousin. Reference to his actions afterwards, self-mutilation. The fresh evidence raises a credible defence of diminished based on borderline personality disorder and alcohol and drug-induced psychosis. It should have been raised at trial. The interests of justice require it be considered now. It may be that when tested by cross-examination and any medical evidence that the state decides to adduce, it will be seen the fresh evidence doesn't support the defence. In the result, for the reasons we've given, the case must be remitted to the Court of Appeal for them to hear the evidence and any further evidence that may bear on the issue, and so on. And so, in light of Brown and Daniel, we submit that the principles are clear.
Can I just begin?
Yeah.
For paragraph 40,
Yes.
Professor Eastman's conclusion in that case was was in pretty strong terms, wasn't it? Very likely, and so on, direct
Yes.
interaction.
Well, he's pretty confident in this case.
Well, I was just wondering, what is the high point of what he says in this case? I mean, he puts it in different ways at different times.
Yes, I think it's, let me just get the relevant section. His report, the main report, is in volume 4 of the record at electronic bundle 1528. That's where it begins. And his opinion section begins in paragraph 154 at electronic bundle page 1543. And at 154 he acknowledges the difficulty in assessing the case medically because of the lack of detailed medical assessment around the time of the two trials, also prior to that or subsequently. And then reference to 155 to the St. Anne's Hospital admission. He then deals at 166 with psychosis.
We need,
At
161
Yes.
expresses his very much on balance view about the antisocial personality disorder.
Yes. Yes, if one had to determine whether it was more likely than not the appellant exhibited antisocial personality, then with considerable hesitation one might conclude that it was. This amounts to a diagnostic condition with little data as a foundation, yes. So he's not entirely satisfied that that is reliable. He deals with drug and alcohol dependence, and at 166 the history I gained on quite extensive assessment combined with the information I gained from the mother strongly suggest he has, at the very least, experienced episodes of psychosis. And the next one, some of the symptoms are somewhat suggestive indeed of ongoing illness. However, it might have been the most likely diagnostic conclusion in regards to psychosis he experiences and has experienced since probably his mid-teens psychotic symptoms in episodes most likely precipitated by drug ingestion.
And I was just looking for some, I mean, in the other case, he was very clear, A, very likely there was a connection, B, likely at the time of the index offence.
Yes, if you, para 190, I think, answers my Lord's question. Page 1549. The history I gained from the appellant
More
points...
likely than not.
More likely than not, at the time of the attack on the victim of the index offence, he was in a psychotic state. So,
Yes. What's that based on?
well,
It's based on the foregoing, isn't it?
it's based on...
On the foregoing, on
It's based on everything.
Yeah.
It's based on the assessment that he's made, never made before, a thorough, comprehensive assessment, interview with the appellant on the specific question of his mental health and history, his mother, all the records.
No, I understand all that, but it's just the relation to the index offence.
Well, he goes on to put it in context about the history of taking cannabis and of taking drugs on the morning of the offence itself and how that could endure for hours or days. Again, in a sense, these are issues which Professor Eastman can't be interrogated or tested before the board.
No, of course.
The point is, he has given the opinion, he has the distinction he has. Could I deal by reference, sorry to flick back, but this recent case of Mr. Blackman, who was the Marine who was convicted of murdering a Taliban insurgent, and then fresh evidence was admitted by the Court of Appeal. There's an interesting section about the ability of a forensic psychiatrist to reconstruct mental health many years after. It's supplementary authority bundle. It's not got an electronic bundling reference, I'm afraid, but it's tab 2. And the point about it is that deliberate decision was taken not...
Which bundle are we in?
This... supplementary authority.
Yes, thank you.
Tab 2. I'm sure the board can recall generally the facts of the case. This was a Marine who was recorded with his camera and a microphone finishing off a dying Taliban insurgent. And he was convicted of murder at his trial with no psychiatric evidence being advanced, although there was some evidence available to him to suggest he was suffering from combat exhaustion. But the fresh evidence, which was unanimous on appeal, was of an adjustment disorder. And so the issue was would he be allowed to run the defence? Would the court admit the evidence, notwithstanding it not being advanced at trial? And I refer you to it for one point about the ability to go back, or for a psychiatrist to reconstruct a mental state some years after it. Paragraph 35 of the judgment of the Court of Appeal. There's a heading, the absence of a report prior to trial and conviction. The psychiatrist stated they were surprised that no psychiatric report was requested prior to the conviction. Nonetheless, it was routine for them to reach a conclusion relying on historical information and a mental state examination. In the case of the appellant, this was explained by his personality, which was such that he wouldn't link his poor sleep and irritability to a psychological condition. Dr. Joseph also concluded the appellant would not want to rely on a psychiatric defence because of the stigma that was perceived to attach to it. This is consistent with the disclosed note of a conference that the appellant's then leading counsel had with him in June 2013, which records counsel observed that psychiatric assessment would only inform a board of the background, quote, rather than be evidence that you behaved in an out-of-character manner, with which proposition the appellant agreed, saying it would be a, quote, created scenario. And then at 78, para 78, the court's conclusion is set out. The prosecution contended there was no contemporaneous evidence relating to his suffering from an adjustment order. The evidence should be disorder. The evidence obtained after conviction was insufficient to show he had an adjustment disorder or that there was any substantial impairment. We've set out at paragraph 35 the experience of the psychiatrist that assessments can properly and routinely be made at a time significantly after the events to which the assessment relates. Clearly much better if there'd been an assessment by the prosecution prior to the court-martial, but that didn't happen. And then a reference to Robinson in the Privy Council when discussing the process for considering diminished in England and Wales. Perhaps I can just leave the board to read that quote. Then goes on to say the practice again referred to in gold. Unfortunately, it's the experience of members of this court that in cases before the ordinary courts, the routine practice, that means the ordinary courts of England and Wales, the routine practice of the prosecution in obtaining reports is no longer followed. This appears to be related to the very real delay that obtaining such a report incurs, along with the increasing costs involved. Many cases such as this may be entirely justifiable, but it's particularly unfortunate in any case involving conduct which is entirely inconsistent with the prior character and conduct of the defendant. This is even more so in a case such as this, where in any event there's a real responsibility on the armed forces in respect of mental health. And then they go on.
How long after the event was the evidence obtained?
It was, I think the killing was in 2011, and so the fresh medical evidence was 2013, so it was just over 2 years after. But the principle is the same, and in all of the cases we've seen, one is looking at an expert witness, a forensic psychiatrist, coming on the scene some years later, doing the job that should have been done at the time, and coming up with a diagnosis. And while I fully accept that no doubt the state would have questions to put about the reliability and confidence with which Professor Eastman expresses his view, and would also want to know more about the circumstances in which this issue was or was not even considered at trial by defence counsel. Those are, in my submission, in light of the case law which I've referred you to, matters really for the Court of Appeal to resolve rather than the board. The real question at this level, in light of the case law, is simply whether the board accepts that what it is faced with is credible and compelling evidence on the face of it, which raises a question about the fairness of the trial process and the reliability and safety of the conviction. Lords, I could go into more detail.
Well, I think that probably sums it up, doesn't it?
I don't think I need to take up more time unless I can assist the board further.
Thank you very much
with
indeed.
Submissions.
Ms. Buckley? Thank you. Mr. Poole?
My Lord, I'm grateful. My Lords, I propose to follow the structure of the respondent's written case and begin really by summarising the respondent's position on the two grounds, but obviously focusing really on the fresh evidence diminished responsibility point, as my learned friend has. The respondent fully accepts that the board has a wide discretion, but submits that that discretion to admit fresh evidence in the case of this nature, namely where the appellant seeks to rely on fresh evidence to raise diminished responsibility on appeal after unsuccessfully running an entirely contrary defence of denial at trial, it is only in an exceptional case that fresh evidence should be admitted in the interests of justice. And in support of that sort of principle, so one needs look no further than the case of Richard Brown. There are confusingly two cases of Brown, both that went to the Privy Council. This is a case that you haven't been taken to so far. It's in the first volume of Authorities at tab 7, electronic bundle page 1871. I think I'm right in saying this is probably the most recent sort of exposition of these principles in the Privy Council, and what I mean by that is that this was a case where there was an application to admit fresh evidence, questions of diminished responsibility being run, and judgment given by Lord Toulson. And if I can ask you to have regard to paragraph 32, page 1881 in the electronic bundle. Lord Toulson remarks in the second sentence, there have been numerous cases in England and Wales in which an appellant has sought to raise a defence of diminished responsibility on appeal after unsuccessfully running a different inconsistent defence at trial. The Board considers valuable guidance is provided by the case law of the Court of Appeal, leading authorities Erskine and Williams. And then 33, referenced Erskine and Williams, decision whether to admit fresh evidence, fact-specific. Court has a wide discretion focusing on the interests of justice. And then, however, if an appellant were allowed to advance an appeal, on appeal a defence which could and should have been put before the jury, trial process would be subverted, unlikely to be in the interest of justice to allow it to be raised on appeal unless a reasonable, persuasive explanation was given for the omission. And what one takes from, in my submission, the Court of Appeal in Erskine and Williams, which the Board also has, this is in volume 2 of the Authorities, tab 17, electronic bundle 2043. Paragraph 39, reading at E. The fact that the issue to which the fresh evidence relates was not raised at trial does not automatically preclude its reception. However, it is well understood that, save exceptionally, if the defendant is allowed to advance an appeal of defence and or evidence which could and should have been put before the jury, our trial process would be subverted. So that's what Lord Toulson is quoting in Brown. And it requires a reasonable and persuasive explanation. Now, noting that It goes without saying, when the board is making a decision whether to admit fresh evidence, each case turns its own facts. We submit this is not a case where the interests of justice are served by admitting the fresh evidence. And we say there are four matters that stand out and set this case apart from cases where fresh evidence have been admitted, such as those heavily relied on by Malone Friend, namely Marcus Daniel and Nigel Brown. So those four matters, we say, first, there is a strong inference that the decision to deny the offence and not advance diminished responsibility was a deliberate decision by a defendant whose decision-making facilities were unimpaired. Second, we say there is no scope for diminished responsibility on the facts of the case. We say the evidence presented that this was a premeditated murder, and this is how the case was put to the jury. Third, we say that the appellant, unusually, when one looks at all of the cases where fresh evidence has been run to advance diminished responsibility, unusually here, the appellant consistently maintains his denial. And there's no reason in my submission to suppose that that would change and that the appellant would now advance a defence contrary to that which he has steadfastly maintained. And fourth, even if the board is unpersuaded by those first 3 points, we submit when one looks at Professor Eastman's evidence and looks at it with the necessary anxious scrutiny that a case of this nature requires, and one sees that from cases such as Tate and the board's judgment in that case, we submit that Professor Eastman's evidence fails to show that the appellant had or would have a viable defence of diminished responsibility. Having acknowledged by reference to Erskine and Williams that each case is fact-specific, and in my submission the board derives very little assistance being taken to other cases where fresh evidence has been allowed. Given the way Malone Friend puts his case, and certainly opened his case, and the reliance placed on Marcus Daniel and Nigel Brown, I think it's important at the outset that the board understand why I say that they are very different cases and can be clearly contrasted with the present appeal.
Can I just ask in relation to your third point?
My Lord.
Am I right in understanding then that the appellant is still denying he committed the killing?
Well, my Lord, I think in order to answer your Lordship's question,
I think Mr. Owen shaking his head.
Well, my Lord, I'm sure I'll be corrected if I say anything that's incorrect in reply. But I think in order to answer your question, if I can ask for, there's a small clip of emails that were disclosed by the other side yesterday, because your Lordship have, sorry, if I can ask those to just be handed to the board. Your Lordships have in the bundle in volume 4 at electronic page 1559, a letter dated the 8th of March 2016 from Mr. Raj Kumar. Now, Mr. Raj Kumar was counsel who represented the appellant on appeal in the Court of Appeal. And this letter is a response to the letter you see on the following 2 pages, 1560 and 1561, from those instructing Malone and Friend. And what Mr. Raj Kumar says in this letter is he confirms he appeared on behalf of Mr. Chandler on appeal. At all times during the appeal and at trial, so far as I'm instructed, Mr. Chandler denied the incident. And then he goes on to say there was no issue of mental incapacity at any time with regard to his instructions of his defence at trial. And then, however, I'm of the view that since the decision in Lewis, it may be prudent to have accused people tested for mental incapacity, especially in circumstances as existed here, where death occurred in such a brazen fashion. Now, the reason I say one should then look at the only one email in this chain of emails, and if I can ask your Lordship to turn to the second email in that clip that you've just been handed. It's an email from, again, Mr. Raj Kumar, 21st of January, so a couple of months before that letter. he says, second line, with regard to Chandler, his instructions had always been that he did not carry out the attack. In taking instructions and speaking with his trial attorney, no issues of mental competence arose, nor did he do anything which suggested to me that he should be assessed. Of course, this was before Daniel and others, given the law of the state, accused people of non-domestic circumstances should be subject to assessment. So, as far as it would appear, certainly Mr. Rajkumar is concerned, the instructions have always been consistent of denial. He's spoken to trial counsel and confirms that instructions have always been consistent. There is no, what I certainly can say is that there's no evidence by way of, as one might expect to see, an affidavit from Mr. Chandler himself saying that, that his position has changed, and if this medical evidence was admitted, he would now be advancing an entirely contrary defence, putting in question his mental responsibility. And when one looks at Professor Eastman's report, the highest that the appellant can put it by reference to that is that when he is asked by Professor Eastman, there is a suggestion that he now can't recall whether or not he killed Kern Phillip. And my lord, let me... I'm grateful. 1536... Paragraph 94, he asked the appellant again more generally about the index offence, and he said that he could not remember whether he had or had not committed it, but then added, but I can't understand, if I did it, why no one describes seeing me do it. But then, in my submission, that statement of the appellant has to be viewed in light of what Professor Eastman later says in his report, which is that the appellant is generally unreliable, and in his view, let me find the reference for your lordships. There's a reference to him saying it's unreliable, and in Professor Eastman's view, it being more likely than not that in fact the appellant can recall the index incident. And it's quoted in our case. If the Lords just give me a moment to find the reference, I will give that to you. Yes, paragraph 203 from 1550. As regards the appellant's claimed amnesia for the index offence, in the event that he was psychotic at the time, then he could have been sufficient to interfere with his memory. However, as I've already indicated, if pressed, I would conclude that it is more likely than not. Sorry, it is more likely that he does have recollection of both the index offence and the alleged assault upon Haynes. And of course, that, in my submission, is supported by the exculpatory defence that's run at the first trial by the appellant giving evidence himself and running a case of denial, and the defence that's run at the retrial through cross-examination of the prosecution witnesses, namely a defence of denial. But it's also, in my submission, and this is, I make some in the written case, we make some comments on the evidence which we say are relevant to your lordship's considerations.
Well, what influence do you suggest the fact that he remains at best evasive? What influence should that have on our decision? My lord, it is one of the factors, and quite a weighty factor, that your lordships should weigh in the balance when considering whether it's in the interests of justice to admit this evidence. Because I submit it is a very unusual case where we have a situation where the appellant has not said in clear terms that he is now prepared to admit
responsibility for, admit killing the deceased. And so you have any confidence that if this evidence was admitted and this remitted, that he would now advance a defence of diminished responsibility. So I say it is, as I put it, it's one of my four perhaps striking or unusual factors in this case, which clearly set it aside from the cases that Millennium Friend relies on as being similar instances.
Surely the factor of overwhelming importance is whether or not he did suffer from diminished responsibility, not whether he's being truthful and honest.
Well, of course, I say, but when one looks at the guidance and the principles to apply, and the factors that influence a decision of whether or not it's in the interests of justice, the reason for not advancing the defence of diminished responsibility at trial is a very significant and weighty factor. And that's why I say it is relevant to consider whether it's right that I say there's a strong inference it was a deliberate decision, whether or not the appellant still maintains this denial. And of course, one then looks, even if you're not with me on those three factors that I say weigh against this being in the interest of justice, I say, of course, one looks at whether there's a viable defence of diminished responsibility. And I say, when one looks at that question on the evidence of Professor Eastman, there isn't on this case. And just before developing those four points, dealing with the points of distinction in the two cases that Millennium Friend took you to, starting with the case of Marcus Daniel, if I may. I think for present purposes, other than reminding the board, this is under tab 8, electronic bundle page 1887. Starting point is that recognised by Lord Dyson at paragraph 43 of that case, where he starts his conclusion, the board's conclusion, by saying that this is a most unusual case. Marcus Daniel was a man of previous good character who killed his cousin who he was in a close platonic relationship with. He admitted killing, but denied that he intended to kill her. The circumstances of the killing, including self-mutilation because he cut his fingers afterwards, were all suggestive of substantial impairment. There was concern about Daniel's mental state, such that he spent 2 months in a psychiatric hospital following remand. And the issue of diminished responsibility was considered by trial counsel, but not advanced because the evidence wasn't there to support it. So clearly this was not a case of a deliberate decision not to run that defence. Now, contrast that to the present case. When one looks at the facts, we say, and for reasons I'll develop, this was clearly a premeditated attack. There was nothing in the way that the appellant presented before or during trial to call into question his ability to give instructions. And there was nothing based on those instructions and the evidence relating to the incident that calls into question the appellant's mental responsibility. That, I say, the marked differences between Marcus Daniel and the present case. Nigel Brown was the other case Millennium Friend took you to. Nigel Brown was a fitness to plead case. So, yes, similar considerations apply with regard to fresh evidence, but I would urge the board, insofar as you look for the defining principles for fresh evidence in diminished responsibility, mirroring Lord Toulson's words in the other case, one really needs to look no further than the Court of Appeal's guidance in Erskine and Williams. But
well, fitness to plead cases are very different in the sense that if he's unfit to plead, there hasn't actually been a fair trial at all.
My Lord, yes, I do, and that's why I say one needs to look at fitness to plead cases differently.
But it also raises the question whether he's fit to give instructions, of course.
My Lord, yes.
It doesn't arise
yes.
here.
And in the Nigel Brown case, you had contemporaneous medical reports that raised issues at the time as to fitness to plead. So it is perhaps unsurprising that that's a case where Miller and Friend can cite fresh evidence being admitted and the matter being remitted to the Court of Appeal. But it's a very, very different case to the present case. And then the final case, only very briefly, I comment on, is the Court of Appeal's judgment in Blackman. And I simply make this observation. That it was, and sorry, for the reference, this was in the Supplemental Authorities Bundle, tab 2. And, my lords, you were taken to a passage about how psychiatrists will reconstruct events at paragraph 35, and then the conclusions of the Court of Appeal. I just wish to highlight what's said at paragraph 69. This is a section dealing with the decision not to plead the defence at the time of the court-martial, and what the Court of Appeal said at paragraph 69, page 42 of the bundle. Critical to our conclusion on this issue is that the prosecution accepted that there was a reasonable explanation for the failure to call psychiatric evidence at trial, and thus failing to advance the partial defence of diminished responsibility. This concession has meant it's right not to conclude it was a tactical decision. Had it been otherwise, it would not have been appropriate for this court to consider the defence at all. And then reference to Erskine. Now, my lord, before briefly expanding on the 4 points why I say it's not in the interest of justice in this case to admit the evidence. In the respondent's written case, paragraphs 5 to 11, which are pages 1751 to 1754, we make some observations about the evidence that have a bearing on the grounds of appeal that are advanced. I don't propose to repeat what's set out there, but perhaps give your lordship just the sort of headline points in my submission.
Sorry, we're going to your case at paragraph.
Yes, paragraphs 5 to 11, so 1751 through to 1754. And in the headline points that I think your lordship already have a handle on in any event is that the first trial, the appellant gave evidence, and a summary of his defence is set out in our written case at paragraph 7A and 7B. You have a transcript from that first trial. It is in a supplemental record of proceedings. I don't intend to take or need to take you to that. There's also a summary that's appended to our written case that starts electronic page 1770. But what is important in my submission is that it wasn't simply a bare denial. There was an explanation for the attack on Kern Phillip. And the appellant's evidence was that he punched Kern Phillip because he had stolen $10 from him, which he had given him to buy some cigarettes with. Kern Phillip tried to punch the appellant. The appellant avoided that blow, then gave chase, but rather limited chase. He was then stopped by prison officers, and then he was beaten unconscious by prison officers. And he maintained that account under cross-examination. And insofar as there were issues of mental capacity, or the appellant's mental state, the cross-examination is a fairly detailed cross-examination which the appellant withstands and says at one point that he wanted to teach Kern Phillip a lesson for taking money from him. We know the appellant didn't give evidence in his retrial. There's an exchange between the judge and Mr. Williams, who appeared for the appellant, before the decision is taken whether or not to give evidence. Your lordships have that quoted at paragraph 8 of our case, but I submit in when one looks at that exchange, it's quite clear that there's been extensive dialogue between Mr. Williams and the appellant, and Mr. Williams says that the appellant fully understands both sides, the pros and cons, and appreciates that, and he prefers to remain silent. The appellant's defence at retrial is again one of denial through cross-examination. Detailed instructions have obviously been given to Mr. Williams, who was admittedly counsel in the first trial as well. The reason I say detailed instructions must be given because what was put to the witnesses, the prison officers in particular, is that they were lying. The appellant specifically denied asking to be handcuffed to the deceased. He denied that he was carrying a weapon, and obviously he denied stabbing the deceased. It was put, though, to certainly prison officer Mohammed that the appellant cuffed the deceased. And that was a theme that was developed in the defence closing arguments, and you've got the references are in the written case, but the cross-examination where that's put is page 156, lines 1 to 3, and in the defence closing where reference is made to it is 1226, line 31. So it was clearly before the jury that there was, to use Professor Eastman's words, an ordinary explanation for this incident. Some evidential points regarding the Haynes incident, which, given Miller and Friends' emphasis on the first sort of 3 grounds of appeal, I don't propose to develop orally. Your Lordships have it at paragraph 11 of our written case. And what paragraph 11 seeks to do is explain why we say the criticisms that are made by the appellant of the judge's directions on the Haynes incident are and without merit.
Yeah.
And we say when one looks at the evidence that's adduced at trial regarding the Haynes incident, there are repeated references to the date of it. There were repeated reference to the date of the incident in the judge's summing up, and the jury in our submission would have left in no doubt, because one of the criticisms made is that the jury were not reminded that this was a subsequent event that happened some 4+ years after the index event. Well, in my submission, when one looks at the evidence and the summing up, the jury would clearly have in mind the date of the incident and would know the time lapse between the two. My Lord, turning then to the fresh evidence, and I can probably be fairly brief in developing the 4 points I've given in summary already. The legal principles are not an issue between the parties. I've taken you to what the said in Richard Brown and what the Court of Appeal said in Erskine and Williams. The first point which we say mitigates in favour of not admitting the evidence is that this is a tactical or deliberate decision. As I, in answer to my Lord Kerr's question, submitted that explanation for absence of evidence at trial is a very relevant factor when considering the court's discretion. The best authority for that principle is the more recent judgment of this board in Pittman, which your Lordships will find under tab 12, electronic page 1979, and the judgment given for the board by Lord Hughes in that case. And it's paragraph 48 that I have particularly in mind. This is specifically considering diminished responsibility and fresh evidence. And Lord Hughes says at letter H, not only must the evidence appear credible, but the explanation for its absence at trial is very relevant to the exercise of the discretion. And I say on the evidence that's available before the board, the strong inference, and the very strong inference, as this is a deliberate decision taken, although intellectually possible, it's tactically disastrous in my submission to defend a case as a denial of the killing, whilst at the same time saying, well, if it's proved, then responsibility is limited. And raising an issue of mental health in this case would have required emphasis on the irrational, the irresponsible. It would have cut directly across the case that was put through cross-examination of the prosecution witnesses. And moreover, and this is an important consideration when considering whether it was a deliberate tactical decision, this is not a case where the material cause for refusing to permit diminished responsibility to be run at trial is mental condition. And there's a case of Borthwick that I don't need to take the board to, but Lord Justice Kennedy's phrase in Borthwick there was that the choice was not forced upon the appellant. And I say this is a clear case where the choice was not forced upon the appellant. Three very short points to make good that submission. It's accepted the appellant was fit to stand trial. That's not an issue that's pursued on appeal. It is clear in my submission, for reasons I've expanded on, that the appellant was able to give detailed instructions to advance the exculpatory case that he wished to advance. And third, there's nothing in Professor Eastman's report to suggest that the mental condition that he opines on impaired the appellant's ability to give instructions. The second reason that we say it's not in the interest of justice in this case, this is a point made at paragraph 22 of our case, we say there's no scope, in fact, for diminished responsibility on the evidence. The conduct and nature of this premeditated attack does not, in my submission, suggest responsibility that was substantially impaired. The appellant was carrying an improvised weapon. He asked to be handcuffed to the deceased. He chased the deceased away from prison officers to the south wing of the prison. He refused to drop the weapon when he was apprehended. And there's no suggestion from any of the witnesses that gave evidence that were there at the time to suggest the appellant behaved unusually or was acting in an abnormal state of mind.
Is premeditation necessarily inconsistent with mental abnormality?
My lord, no. Look, one can envisage cases where no, it is not. I say, though, it is a factor to take into account whether or not there was premeditation. When weighing up in the round this question of whether it is in the interest of justice. And moreover, in this case, it is, again, unusual because it wasn't simply a bare denial. It was put, as I've already referred to, in cross-examination and formed part of the defence case, that, in fact, the appellant cuffed the deceased. And I say, when one looks at Professor Eastman's report, where he says, effectively, if there was evidence of cuffing, or an ordinary explanation for the index incident, then this tends to weigh against a conclusion in favour of substantial impairment. And then the third reason, which the board already has, is the appellant maintains his denial, and you see why I say that. And we're in, I'll hear what my learned friend perhaps has to say in reply. It may be said, well, it's implicit in the fact that this appeal is being advanced and the appellant would have been informed by his legal representatives that the issue is whether evidence that goes to the question of diminished responsibility of substantial impairment, there's an application to reduce that evidence. It may be implicit that his instructions are that he's going to change his defence and admit the killing. I say that's a very unsatisfactory state of affairs to operate on an implied admission by the appellant. And as I say, it cuts across what his consistent instructions have been to his trial counsel and appeal counsel today, and the evidence that he gave at both the first trial and the retrial. Turning then to the fourth point, namely no viable defence of diminished responsibility. We make submissions our written case in this regard, starting at paragraph 26, page 1760. At paragraph 27, I seek to summarise the effect of Professor Eastman's evidence. And again, I don't, as it's fairly fully set out over a number of sub-paragraphs running through to page 1762, I don't propose to repeat what is said there. other than to make an observation that Professor Eastman found it very difficult to assess the appellant's case medically because of the lack of assessments both before and after the two trials. And a number of his expressions of opinion in his report are, in my submission, tentative at best. And when one looks at the key expression of opinion, namely that it is likely that the appellant was suffering from a psychotic episode at the time of the killing, I say there is reason to sort of doubt that finding based on a sort of forensic analysis of the report, and I'll develop that point in a moment. But we say there are 6 reasons why there's not a viable defence of diminished responsibility in this case. And we make these points at paragraphs 28 onwards in the written case, and I'll only develop them briefly. Firstly, and this is the point I was just alluding to, the critical finding, and I think it assists to have Professor Eastman's report to hand. So this is volume 4, starting page 1590. Sorry, that's his second report. His first report, 1528.
Yes.
The critical findings in my submission are those at paragraph 190 and 191, page 1549. The board was taken to 190. Invite the board to have regard to what's said at 191. So, having said that, more likely than not, based on the history he gained from the appellant, Professor Eastman says specifically he gives a history of having taken cannabis as well as possibly came close to the time of the attack. Specifically, and then he refers to taking drugs at 4:30. Now, the reason it is, in my submission, important for Professor Eastman's purposes that there has been the ingestion of drugs at 4:30 is because the link that Professor Eastman makes between the ingestion of cannabis and the hearing of voices, which he expounds at paragraph 90, if I can ask the board to just turn back to page 1536. So they're talking about the early morning of the index offence. I then asked the appellant whether he had mental experiences around this time, and he said hearing voices, noises. I wasn't understanding clearly what they said, it was more like noises. And then he said, I can't recall if they instructed me. He said that these experiences had occurred during the night of the alleged offence, but he had not had them when the prison officer had come to his cell. He then said that the experiences started again the night after. And then specifically at 91, he's referring to the hearing voices 2 months prior to the index offence. I asked him what sort of voices. The appellant said he had not heard the voice during the period of 2 months up to the index offence. Now, in my submission, what is being said there by the appellant is that he's taken cannabis about 4:30 in the morning. We know the index offence was about 11 o'clock later that day. He was hearing voices, but he was not hearing voices when the prison officer came to his cell. I say in my submission that is important because it calls into question the conclusion that Professor Eastman reaches at paragraphs 190 and 191. Because the history that was relayed to him was of not hearing voices at or around the time of the index offence. And in fact, the appellant's evidence was that he had not heard the voices or experienced symptoms for 2 months prior to the incident. And you see that at paragraph 181 as well of the report.
Are these not points that would be made to Professor Eastman if he was giving evidence?
My Lord,
I mean, unless you can demonstrate to us, I suppose the appellant would say, unless you can demonstrate to us that these are clinching points, that they really destroy Professor Eastman's evidence, is it not necessary that the matter be remitted to a tribunal which contests the evidence in the way that you seek to now?
My Lord, in answer to your Lordship's question, firstly, yes, of course, these are points that would be put to Professor Eastman, and his evidence would be tested if this was remitted to the Court of Appeal. But the critical question for the board is whether there is a viable defence of diminished responsibility. Now, I don't say that this first point is, as it were, a knockout blow. I say that there are 6 reasons why.
Yes, well,
Professor
let you
Eastman,
develop those.
Professor Eastman's opinion is sort of undermined. And I do say that the credibility of his opinion is undermined in 2 important respects. And first, this instance where his critical conclusion seems to be premised on a false basis. And secondly, I do say his opinion is largely based on the appellant's account. And again, the 2 points are interwoven because this turns on his finding, the respondent saying when he took drugs and when he heard voices. And it being based on the appellant's account, we then have Professor Eastman saying the appellant is unreliable. So as it were, that's the first point. The second point is a point already made when considering the broader question of interest of justice. Namely, I say the overwhelming inference is that the appellant was not in a psychotic state at the time of the killing, from what we know from the evidence and the way, in fact, he advanced his defence. He knew what he was doing. He knew what he was doing was wrong, and we were able, in my submission on the evidence, to exercise willpower to control his actions. So I say, in fact, defence of diminished responsibility is not available, and that's another reason I say, perhaps to cast doubt on the credibility of Professor Eastman's report, because I do say he fails to take into account the totality of the evidence, which shows that this was a premeditated murder. And Professor Eastman did have the summary of the evidence from the first trial, so he knew what the appellant said at the first trial and the defence that was advanced by the appellant there. The third point has been addressed by, so the point here is the way in which Professor Eastman expresses himself appeared at first blush to be slightly inconsistent with the guidance of the Supreme Court in the case of Golds. Now, it's fair to say Professor Eastman has put in a 4th report saying my criticisms of him in that regard are wrong. He's read the judgment of Golds and his opinion remains that there is a basis to put substantial impairment before a jury on the evidence. Now, the board has what he says. I say when one looks at his first report, the language he chooses to use is inconsistent with what the Supreme Court have now said is the true legal test.
Golds hadn't been decided at the time.
Absolutely, my Lord, yes. The 4th point we make is in fact, Professor Eastman's evidence doesn't disclose a relevant disease or inherent cause on the basis of drink or drugs. Perhaps best to make this point by reference to the case of K, which your Lordships will find under tab 20, electronic bundle page 2101, which was a case where the defendant relied on partial defence of diminished responsibility. He submitted that he was heavily intoxicated with drugs, but it was primarily the underlying schizophrenia which was responsible for his psychotic state. And so this is a sort of involuntary intoxication case, in a sense. And what one sees are the conclusions at paragraph 16 of Lady Justice Howard. The law does not debar someone from schizophrenia from relying on the partial defence of diminished responsibility where voluntary intoxication has triggered the psychotic state, but he must meet the criteria in section 2.1. And then jumping about 7 lines down, however, if an abnormality of mental functioning arose from voluntary intoxication and not from a recognised medical condition, an accused cannot avail himself of the partial defence. And 17, the defendant in this case therefore had to establish either that intoxication was involuntary and together with schizophrenia substantially impaired his responsibility, or that schizophrenia standing alone substantially impaired his responsibility. Now, in the present case, the evidence does not, or Professor Eastman rather, because that is the medical evidence that's relied on, does not support the notion that the appellant's taking of cannabis was involuntary. This isn't a sort of a consumption that was involuntary as a result of an irresistible craving or compulsion. There's no clear diagnosis of a relevant disease, namely an antisocial personality disorder is very tentatively suggested, but there's no clear diagnosis. And so, in actual fact, when one looks at Professor Eastman's evidence, my submission, it doesn't support a viable defence of diminished responsibility. And our final point, because the fifth point is linked to one I've just made, our final point in this regard is a point already made that Professor Eastman says in his report that if there is an ordinary explanation, then that rather weighs against finding of substantial impairment. I say the way that this matter was put to the jury must have found that there was an ordinary explanation, not only by reference to the evidence of cuffing the deceased, but by the way, in fact, that the prosecution witnesses were cross-examined on the instructions of the appellant. So for those cumulative reasons, I say there's no viable defence of diminished responsibility. And for the other reasons, I say this isn't a case where the interests of justice favour admitting the evidence. If I'm wrong and the evidence is to be admitted, then you'll see from our written case we join issue. Obviously, this is a matter that should be remitted to the Court of Appeal to consider with any further evidence from the state. Well, I'm more than happy to adopt my learned friend's approach and, as it were, not make any oral exposition of what we say about bad character. You have our response on that regard at pages 1765 through to 1767. And one further point, we say if there has been a misdirection, acknowledging that this is a capital case, and so you have the guidance in Beckford and the Queen of utter certainty, we do say that given the strength of this case and as the Court of Appeal alluded to, 21 pieces of circumstantial evidence, this is a case that it would be appropriate to apply the proviso if you would find that there's been a misdirection. As regards my learned friend's suggestion that if this matter is remitted on the diminished responsibility ground, and the board thought that this was he had a good point about bad character, the board should express some views about this to inform the courts in Trinidad below. In my submission, I say first, it's not a good point. It's a bad point for the reasons in the written case, and the board should turn down the offer, as it were, or the suggestion that they give guidance, because there's certainly a Court of Appeal authority in England and Wales that bad character direction should not be prescriptive. And the case that I'm in particular thinking about is the case of Campbell, which your lordships have at tab 16, where the Court of Appeal looked at the Crown Court compendium and suggested that there was no need to be as prescriptive as was set out there, and it's the judgment of Lord Phillips. It's electronic bundle 2027, and in particular the passage I had in mind starts at paragraph 36 and ends at 43. Lord Phillips saying it's of course clearly highly desirable that the jury should be warned against attaching too much weight to bad character evidence, let alone concluding the defendant is guilty simply because of his bad character. And the thrust of that judgment is that provided that clear warning is given, which it was in this case, there is no need to be prescriptive, and certainly no need to expressly remind the jury of the length of time between the instant they were looking at and the instance of bad character. But as I say, those points are developed more fully in the written case, and as my learned friend didn't orally develop them, I won't do the same unless your lordships.
No, thank you very much. Thank you. Mr.
Well, as I can be very brief, the fundamental problem with Malone and Friends submissions is that they don't really take on board and confront the reality that Professor Eastman, of his report, its conclusion, which we've already dealt with, and the fact that that opinion has been maintained in the face of the very criticisms or observations that Malone and Friend has summarised. I'm referring to the second report of Professor Eastman, which is Electronic Bundle 1590 in Volume 4. I won't take you through it all, but you will see in the face of the submissions lodged by the state prior to the grant of leave in August 2016, these points were put to Professor Eastman, question by question, and his answers are there and his opinion is unaltered. Specifically, for example, on 1593, one sees questions 5 and 6. He's asked about the relevance of his findings on the appellant's history of dependence on cannabis and alcohol, and he gives at 22 and 23 his answers. And those answers make clear that there plainly is, if the evidence is accepted, a viable defence of diminished responsibility. The inherent disease is not one of cannabis and alcohol. He describes at 22, his opinion is the appellant is genetically vulnerable to psychosis. Additional to this, it's recognised that prolonged cannabis ingestion is a separate, distinct and major risk factor for the development of psychotic episodes. The appellant exhibits 2 risk factors for psychosis: genetic vulnerability and prolonged use of cannabis from middle childhood, and so on. And so, while Malone and Friend could, of course, before the Court of Appeal, probe Professor Eastman along the lines that he has outlined in the submissions in reply, at this stage before the board, the question in my submission is whether the evidence raises a doubt in the mind of the board about the safety of this conviction, the potential safety of the conviction and the fairness of the trial process. And the board would have to, bearing in mind the nature of the case, that it's a capital case, the board would have to be sure that this report can be dismissed at this stage without testing before it would decline to remit the case for further investigation before the Court of Appeal. And in the face of Professor Eastman, who needs no praise or confirmation from me as to his expertise and his experience, this is his report. And it is the only report that has gone into Mr. Chandler's medical history and his likely mental state at the time of the index offence, and that his opinion is, more likely than not, in a psychotic state. That is a defence of diminished responsibility. The board would have to have overwhelming evidence that this opinion is not worth the paper it's written on, in effect, before it could decline in my submission to remit the case for further consideration. The points that Malone and Friend makes, that there is a strong inference that a deliberate decision was taken by an unimpaired, fit-for-trial defendant not to run diminished responsibility, it is an impossible conclusion for the board to draw in the absence of any explanation from the defence barrister at the trial as to what actually happened. And in the clip of correspondence that was handed up, just there are the emails that fill in some of the gaps that my friend has referred to, but at the very last page of the clip, you'll see that as recently as last week, my instructing solicitors made one final effort to get Mr. Williams to respond to our requests for assistance. I asked that a final letter be written to him. We sent the original letter in January 2016 and then numerous follow-up emails to him But bearing in mind that in effect, we would be criticising the absence of any response, I suggested that a final effort be made to contact him. And again, we've had no answer. Now, my learned friend suggests that he sought to distinguish the case of Daniel and Brown from this case. And he said, for example, in relation to Daniel, well, Daniel was a case where there was no evidence to support diminished responsibility. Well, the same is true here on the face of it. There's no evidence of any attempt by the defence to obtain a psychiatric report. All we do have are the documents which Professor Eastman has dug up, and it includes that letter in 2005, which I've shown you, which, as I say, cries out for further investigation, should have led to, if it had been seen, and one assumes that any competent defence lawyer would want to investigate the issue of mental health thoroughly. And so, in the circumstances, it's impossible in my submission for this board to conclude that there was a deliberate decision not to run a viable defence. There was no evidence that there was any evidence capable of being raised with Mr. Chandler. No scope on the facts because it's premeditated. In answer to my Lord Sumption's question, my own friend obviously correctly said, well, of course, the fact it's premeditated is neither here nor there. If you're in a psychotic state and voices are compelling you to attack your friend because there was some evidence, just as in Daniel, where it was said it's unusual because the defendant was obviously close to his cousin whom he savagely murdered, or killed rather. On the evidence, here was a man who was friendly with this person, Mr. Phillip, who was killed.
Well, was he?
Well, there was some evidence that they were friendly. They were at least acquaintances until the dispute about borrowing or stealing money. I accept the Crown's case, prosecution case was, this was premeditated. You decided to kill him because he'd stolen money from you. But on the face of it, the circumstances of the killing are so brazen, in broad daylight in front of vast numbers of witnesses, including prison officers. Here's a deliberate attack on a man. It certainly cries out for some medical investigation. But the basic point is the fact it's premeditated isn't inconsistent with it also having been done in a psychotic state. And so that is not fatal to Professor Eastman's analysis. The point about consistently maintaining the denial, again, it doesn't take us very far. Plainly, he maintained his case, his defence of denial at the trial and at the retrial. And as for the suggestion that, oh, well, maybe he'll maintain it again, I mean, the fact is, he knows what this case is about. Mr. Lairfreund has visited him in Port of Spain. He's well aware of the implication of this. I mean, the idea that we need a statement from him to say, oh, now I will run diminished responsibility is unrealistic. I mean, a defendant could always change his mind. I mean, if the case is remitted for retrial, he could change his mind at the last minute. The fact at this stage is there a viable defence based on fresh evidence? Is there a reasonable explanation for it not being adduced before? Is it in the interests of justice to admit it? And on all those bases, and with great respect to my own friends' detailed points, they are not points that can be resolved here. They are points that should be resolved before the Court of Appeal. At this stage, we submit Professor Eastman's evidence is plainly sufficient to remit. Unless I can assist.
Thank you very much.
Those are our submissions.
And the board is grateful to Council for their economical as well as persuasive presentations, and to those who were responsible for the preparation of the respective cases. The board will take time to consider its judgment, and it will be delivered in due course.